sound and make sure that we are. Yep, sounds like we're working, so that's good. All right, so today we will probably not take the full time because it's a rather short chapter. And that'll give you some time to start working on the second exam. So I'll give you some class time to do that. Also, the quiz for chapter 5 is due. So I'm gonna let you do that. If you feel cheated by my not taking the full time again, you let me know and we'll stay late next Tuesday. I've never, ever had anybody take me up on that offer. Education is the one service where more seems, or where less seems to be more with you. Like the less you get, the happier you are. I don't understand that, but you know, that seems to be what students prefer, is like the less I give them, the more happier they are. So I was just talking about how one of my colleagues at another institution, who shall remain nameless now that I'm on camera, decided to take the first week of class off so that she could go skiing, and how her students were just ecstatic about that. It's like, well, your students may be ecstatic, but I'm not sure your department chair is going to be ecstatic about that. So, you know, I mean, we have this like requirements from the regents that we're supposed to have a certain number of contact hours, right, in the semester. So anyway, we're going to talk about rights in the workplace today. So let's talk about some of these situations that are based on real cases that have actually occurred in the workplace. I like the first one because I teach in the sales program, so this is a prime example of ethics in sales. So in this case, a salesperson is fired right before their commission is set to be paid, and as a result of their contract, it says that if you separate prior to the end of the quarter, you don't receive your quarterly commission, and the commission went to his supervisor instead, who was the person who terminated him. This one is like, you would have to have the ethical sensitivity of a gnat to not get that this is probably a bad idea. Right? I mean, that one seems pretty straightforward. What about, though, screening for nicotine? This is based on a health insurance company that did this. They screened for nicotine in your system, and if they found it, they gave you a certain amount of time to quit smoking or face termination. Should companies be able to do that? We screen for drugs, don't we?
Nicotine is legal.
Nicotine is legal? Okay. Well,
So is smoking a cigarette.
It's a pretty gray area.
you think it's a gray area? Why do you think it's a gray area?
I don't think it's a gray area.
You don't think it's a gray area? What do
No,
you think what? That
I think that nicotine and vapes are the same. It's just different, like, what's it
so
called?
you're
Different.
in favor of allowing people to smoke, or you're all in favor of the company being able to fire you if you continue to smoke?
I'm all in favor of them firing you. If
You're all in favor
if
of
it's
them
affecting your productivity.
Okay. You think it's a gray area? Why?
I mean, companies have the right to do that unless they're working under federal jurisdiction, I would suppose, but it would be tough to like get away with it, but they probably could. I mean, maybe.
Are smokers a protected class?
I have no idea.
You can fire people for any reason except the wrong reason, right? What's the wrong reason to terminate an employee? You know, based on race, gender, creed, color, things like that. Those are the wrong reasons to, but you can fire people for anything. Are smokers a protected class? The answer is no. Smokers are not a protected class. Although maybe you could make an argument that they are, because I guess you could say that addiction is a disability covered under the ADA, maybe. But in that case, you can say, well, the remediation is he's giving them time to stop smoking. He didn't, the guy who came up with this, the head of the insurance company that decided to do this, didn't predicate it on the fact that smokers were wasting time during the workday, but predicated it on the fact that their insurance costs are much higher for unhealthy groups. And one of the major contributors of having an unhealthy group is the number of smokers you have. It's one of the reasons why higher education, generally speaking, has higher healthcare costs, not because we have a lot of smokers, but because we have a lot of old people that are engaged. Generally speaking, in order to be a professor here at the University of Central Oklahoma, the Harvard of the Hills, the Berkeley of the Blackjacks, the Princeton of the Plains, the Oxford of the Oaks, the Stanford of the Sticks, the Yale of the Yahoos, is that you have to have a PhD. Takes a long time to get one of those generally, right? So generally speaking, and then we have a tendency to hang on to our positions for long periods of time. So we have lots of people that are older than maybe the rest of the workforce and other companies. And so we have a lot of healthcare costs. So he said that, basically it was costing the company a lot of money because these employees actually, use a lot of healthcare benefits. They're sick a lot. And treatment is expensive if they get cancer. And smoking is not just something that causes lung cancer. That's not it, right? It causes lots of other things as well, besides lung cancer. Throat cancer, obviously, cancer of the gums have all been attributed to smoking. Even prostate cancer in men, higher incidences of breast cancer in women, all of those things can be attributed to smoking. So his argument was, look, it's a purely utilitarian perspective. You're costing us a lot more money. That means that everyone, because you contribute part of the payments to your healthcare costs at most places, we have to pay a certain amount for our contribution to the employee share of healthcare at UCO, and you're causing everybody else to incur higher healthcare premiums along with the company. And so we're gonna fine you for that. UCO does this. If you are a smoker, if you use tobacco products, you have to tell the university that you use tobacco, and they increase your premium on smokers. So now where it became really controversial was he went one step further. After he initiated this policy, he then said, because one of the things that they could have happen is if you are exposed to secondhand smoke, you will test positive for nicotine. And so he said, well, if your spouse smokes, you have to get them to quit. Otherwise, we'll fire you. How about that one? That one, again, you can put your spouse on your health care in most places. And so you're causing everybody's insurance premiums to go up. Is that one okay?
I mean, if we're talking legally, it probably is because of what we were talking about earlier, but ethically, it's kind of subjective. To someone that is a non-smoker and their spouse is a non-smoker and they're saying, well, your, spouse smoking is raising our premiums, sure, it would be okay to them, but to the employee who, their spouse is smoking, it's not an easy thing to get someone to quit. And just because they're doing that doesn't mean that they shouldn't have the right to the healthcare.
It's hard. I smoked for a long time and I quit. And it's harder than hell to do it. I mean, it's really, really hard. And I just quit cold turkey. I just quit one day. And I can tell you that along with have a tendency to say what comes into my brain to my spouse is probably the reason that I'm divorced, right? You look like a corpse in pastels, Robin, along with then I'm just, not terribly warm and friendly after I quit smoking for about a year. And I can remember the first time, it is a very, very addictive thing. I can remember the first time, and I haven't smoked for 20 years now. And I can remember the first time I walked past somebody that was smoking and didn't have an urge. And it was last year. I walked past somebody in Paseo who was smoking and I thought, oh God, that's just awful, that smell. But until like about a year ago, I would walk past somebody and think, oh God, that smells good. It's hard to quit. What about firing an employee who's considering having an abortion? Now, in this case, I just put that on there. I have to tell you a little bit of background. They didn't fire her because she was going to have the abortion. They fired her because she told her coworkers, who were all adamantly opposed to abortion, and it created a hostile environment. What do you think about that? So they said, you're the one who created, you told them, and now you've created this hostile environment. We're going to fire you.
I don't feel like that's fair, because you should separate your political views in the workplace.
Well, they weren't punishing her because they thought she was, the abortion was a problem. It was that she was creating, her coworkers became very animated and upset.
That's their problem, not hers.
Yeah, that's kind of what I thought. I mean, my solution, but she's the one who created the problem, according to them, because she told her coworkers. Actually, she didn't tell all of them. She told one of them, who then spread it among the entire office that she was thinking, and they were all anti-abortion, and so they created this, big drama in the office. My solution would have been to fire the one who told everybody. Like, somebody tells you something in confidence, why don't you keep your mouth shut?
But wouldn't that not get rid of the hostile environment anyway?
What?
Like firing the person who.
Or
told
why don't you just
everyone-
tell everybody to shut the hell up and
Yeah.
act like an adult,
Yeah.
right? Rather than firing somebody, why don't you say, well, this is a place of work. This is not what we're here to talk about. You all need to all take a, chill pill and not talk about this in the workplace. This one was a really big one in the early ages, and this is a very old case, but they denied health benefits to an HIV positive employee because the pool was, again, if you have HIV at that time, it was an enormously expensive thing, and you were probably going to cost the company an enormous amount of money. That's still true to this day. If you are found to be HIV positive, it's not a death sentence. And this is one of the things that I find absolutely interesting. I can remember when they first started talking about this and when it first happened, it was in the late 1970s and early 80s. The second person to die of what we now know as HIV or AIDS in the state of New Mexico was a tenant of my mother's. And they didn't call it AIDS at the time. They called it GRID, gay-related immune deficiency. And they thought that it was only transmitted by homosexual men. But it was, I remember at the time, if you coded twice in a hospital and you had HIV, what they called GRID at the time, they would not respond to the code because they weren't sure if the illness was also transmittable as an airborne virus, right? And so it was enormously deadly back then. That's not the case anymore. Most people, have lived long periods of time without ever, becoming AIDS as a specific stage of the HIV infection. And people like Magic Johnson have lived, Magic Johnson's lived with HIV for like 30 years now and never become full-blown, had a full-blown case of AIDS. The drugs now are so good that if you can get to the point where you are no longer detectable, you cannot transmit HIV any longer through sexual activity. But it's still not something that I think most people want to contract. So should you deny health benefits to employees that cost money? Well, the thing about insurance is that insurance is about spreading risk. And, you know, at what point do you stop? You know, like, are we gonna do genetic testing? And if people are prone to getting cancer, we're going to deny them benefits? Largely, this has been done away with as a result of the Affordable Care Act and the fact that they cannot deny coverage based on pre-existing conditions. But prior to the Affordable Care Act, insurance companies and employers could deny coverage based on pre-existing conditions. And so it was a real, you know, I mean, a real problem.
I don't think AIDS is covered under that though.
Pre-existing conditions?
I mean, it's definitely a pre-existing condition, but I don't think it's covered under what they can, I think they can still screen you for that.
No, not according to the Affordable Care Act, they can't.
I was just looking it up and it said under the Affordable Care Act, AIDS is still like something they can screen for.
They can screen, they can't deny coverage.
Or charge you more at all.
I don't know about how, there's a cap on what they can charge to put you in the high risk pool. And employee groups cannot screen for it. You either take the group as a whole or you don't. Employee emails. This is one of the things that I find really interesting because people use email like they used to stand around and talk at the water cooler. And the problem with emails is that they don't disappear. They are discoverable. And in litigation, you may have to produce them. And it can be problematic. And I, you know, when I was associate general counsel here at UCO, people would send me these emails with just absolutely, you know, really inappropriate things, and don't do that. You know, please do not put this in an email. Do you have an expectation of privacy in your emails?
In my personal email, but in my school email, I'm like, well, the university has access to it, so I really don't care because they gave it to me.
So you think that your uco.edu email that they should be able to screen that?
Yes.
They actually don't. They do on D2L, but your UCO email, they generally don't for students. But your employer, you know, could we screen employees' emails?
Yeah.
Yeah. This case is actually the result of a very famous case called Connick versus Myers. And the Connick, it was styled Connick versus Myers on appeal. The Connick was a guy named Harry Connick Sr. He was the district attorney of Orleans Parish, which includes the city of New Orleans. Basically, New Orleans is pretty much all of Orleans Parish. I guess it also includes some of the other sort of cities in that metroplex area. Anybody know who Harry Connick Sr.'s son is?
Harry Connick Jr.
Harry Connick Jr., who is a what?
Kerner.
He's a kind of jazz blues musician, very famous. He's also been an actor. He's played in a number of movies. So he's kind of famous. His father was district attorney in Orleans Parish for an astronomical amount of time. And what happened was he had an employee who basically thought he was not handling the office correctly. And she sent out emails to her fellow employees and they fired her over it. Now, if this had been in the private sector, there would have been no doubt whatsoever that they could fire her over this. And employers constantly monitor. For example, my brother is a tax attorney for Goldman Sachs, and Goldman closely monitors all emails that go through his account. One thing that creates a problem there is because he's a tax attorney, when you do that, you may have waived attorney-client privilege because you're allowing non-attorneys to look at emails, which is one of the things that's sort of problematic maybe. This would not be a case if it weren't for the fact that it happened in the district attorney's office, and she claimed, rightly so, that she had First Amendment protection, that what she was doing was protected by the First Amendment. The courts generally said, yes, that's correct. You do have First Amendment protection, but it's a balancing test with regard to that protection. And the balancing test is, it's not focusing on the content, but rather the actions. And what they said is that her actions were creating a disruptive work environment for the whole office. And so they allowed him to fire her. So when we talk about First Amendment, the First Amendment to the Constitution says, it begins with Congress shall make no law. That's what it says. Regarding, and there are 5 substantive rights included in the First Amendment. So this is what we call substantive due process. One of the things when we talk about employee rights is we'll focus on due process, and a lot of what we'll focus on in terms of due process is not necessarily substantive due process, but procedural due process rather than substantive. So there are 5 rights contained in the First Amendment to the United States Constitution. They are freedom of speech, press, religion, petition of government for redress of grievances, and assembly. Those are the 5 substantive rights in the First Amendment. And it begins with Congress shall make no law. Now, in a case called Barron versus Baltimore, Barron sues the city of Baltimore because they basically create a runoff that impacts his wharf. He is the successor in interest of this wharf, and as a result of the runoff flow that the city of Baltimore creates, sediment sets in, and he can no longer host deep hold ships, which when you're in shipping is sort of important if you're a port. And he argues that the city basically denied him his property without due process of law as guaranteed by the Fifth Amendment to the United States Constitution. And the court said, well, that would be correct if you were talking about the federal government. However, the Bill of Rights in that case, the federal government, the United States Supreme Court said the Bill of Rights only applies to the federal government. It doesn't apply to state governments or subdivisions of the state, which would be things like cities. So for a long period of time, the Bill of Rights only applied to the federal government. It didn't apply to the states. And then we had this major event in American history called the Civil War, which historians have now relabeled as the war between the states. Rather than calling it a civil war, they call it the war between the states. As a result of that war, we get 3 amendments to the United States Constitution. The 13th Amendment frees, it basically enacts the Emancipation Proclamation in all of the states and frees the former slaves. We get the 14th Amendment, which contains the second of 2 due process clauses found in the document. The first due process clause being found in the Fifth Amendment to the Constitution. And we get the 15th Amendment, which grants free men, all free men, the right to vote. Women didn't get the right to vote until the 19th Amendment, by the way. So we gave all free men the right to vote in the 15th Amendment. The 14th Amendment is the most important of the Civil War amendments because it was the intent of the drafter of the 14th Amendment to apply in total the Bill of Rights against the states. So we've never done that. The court has gone through a process of what they call selective incorporation, and they have held that some substantive due process rights are so fundamental to ordered liberty as to be applicable against the states. And of course, the First Amendment is one of those that they say is so fundamental to our sense of ordered liberty as to be applicable against the states. Going back to Connick versus Myers, they say, yes, you have First Amendment free speech rights, but those are tempered by the right of the employer to maintain order in the office. And we're not going to let him fire you for what you said, but rather for the effect that it causes. The First Amendment says Congress shall make no law that's applicable to the states via the doctrine of selective incorporation, which the first example of selective incorporation came in a case called Gitlow versus New York, and it started applying the First Amendment to the states. Now, the interesting thing about the First Amendment is it says Congress shall make no law, and is no an absolute term or is it an equivocal term?
Absolutely.
I think it's an absolute term, right? I think the word no means no. When your mother said no to cookies before dinner, did that mean one cookie?
0.
It meant 0 cookies, right? And if you had the cookie, you put your hand in the cookie jar, you had a problem. The Supreme Court has held that the word no doesn't actually mean no.
How
It
do they
sort of
define it?
means maybe. The classic case involving the first test of this comes in the case in which Oliver Wendell Holmes talks about you can't shout fire in a crowded theater and not be held responsible for that. If you had an absolute right, now I think that's an eminently sensible idea. However, I'm not sure that the word no doesn't mean no, but they've said that with regard to the First Amendment, it is a fundamental substantive right, but there are limitations. And you can place certain restrictions on the First Amendment, like, for example, you can't shout fire in a crowded theater. You can't engage in fighting words. There's something called the fighting words doctrine, which is if you are protesting, for example, and you get up in people's face and you're likely to cause a disturbance of the peace, the Supreme Court has said that those words are not protected under the First Amendment to the United States Constitution. You can use reasonable time, place, manner restrictions on First Amendment speech. So, for example, I don't have to allow, generally speaking, institutions of higher education are supposed to be places where ideas can be debated vigorously in the public square. Now, that doesn't mean that I have to let the neo-Nazi come in and talk to my class. We can say, you can't come in to the classroom and create a disturbance in my class. I can't probably stop them from marching down the mall out here, because that's sort of traditional public space. So with regard to these emails, the court says, look, yeah, you have a First Amendment right, but the employer has a right to maintain orderly discipline among the employees. And email is not one of those things that's a traditional public square. So you can place reasonable time, place, and manner restrictions on it without violating the First Amendment. Now, if it were a private employee, there would be no question that your employer could monitor your employment-based email, right? They own the system. What about pre-employment psychological testing? One of the things that this pre-employment psychological testing asked is, I wish I was not bothered about sexual feelings. I believe there is one true religion. I believe that I think about sex too much. And I love this one. I have had no difficulty starting, stopping, or holding my urine.
I don't know, some positions probably need it, like our police officers probably need psychological testing.
Okay. These are questions from something called the Minnesota Multi-Phase Personality Inventory, the MMPI. It is an extremely rigorous instrument. They're not looking for specific answers to questions in the MMPI. What they're looking for is to see whether or not you answer consistently, for example, in these. And so, yes, the pre-employment testing in this case was used for a security guard position, which included the security guard would carry a firearm. Now, I'm thinking that maybe if you're carrying the weapon, we want to know whether or not you're likely to shoot, indiscriminately, or we're not very far in this classroom from, nobody knows this term anymore, but when I was growing up, we moved to Oklahoma in 1986, right after the Edmond Post Office massacre. If you go just 4 blocks to the west over here of campus to the Edmond Post Office, you can see a memorial statue to the victims of the Edmond Post Office, and that was where the term going postal was coined. So this former employee went into the Edmond Post Office and shot it up and killed a number of his coworkers. And, you know, I think, you know, obviously if you're going to carry a gun, we probably want to know, as you pointed out, if you're a police officer, whether or not you are psychologically sound and capable of executing good decision-making skills under periods of intense pressure and stress. So I think one of the things that we would say is this kind of thing, pre-employment psychological testing, is it context dependent? I think, yeah, if you're talking about police officers and stuff like that, whereas should we do it for example, salespeople?
I don't know, they could go postal.
The salespeople could go postal. They're gonna whip out a calculator and you know.
Well, the guy at the post office,
Huh?
the guy at the post office was just a guy at the post office.
Yeah, okay.
I guess if you make sure that they're not sociopaths.
One of the things that my research focuses on is predicting whether or not people are going to make good salespeople. And there's some evidence to suggest that certain traits are more indicative of good salespeople. Should we engage in that kind of pre-employment psychological testing to determine whether or not you're going to be a good salesperson?
I think we do. They do in the sales workforce.
Some companies.
I mean, they do stuff like that at Target. Like for my interview, I had a whole bunch of like, how do you feel about like different things that Target stands for? Like,
That's different than psychological testing, isn't it?
maybe.
One of the problems you run into with using things like the MMPI is that you run afoul of the Americans with Disabilities Act, because the MMPI is designed to test for you know, certain psychological conditions which are covered under the ADA, and so that can be, you know, a problematic part of it. Denying positions to females that may be detrimental to pregnancy. So not allowing women to participate in certain jobs because it could be difficult or create problems in pregnancy, such as birth defects. This is highlighted by the case of Karen Silkwood. There was a movie that was made starring Meryl Streep. It's called Silkwood. You can see it. It's an Oklahoma case that occurred. It happened right. It's interesting to me because I'm on the city council in Guthrie, and the first time I was on city council, which was 25 years ago, I was running for city council, and you know, you'd meet people and you'd say, where are you from? And they'd say Guthrie. And I'd say, well, you know, I walked every house in my ward and I don't remember you. Where do you live? Oh, West Guthrie. And I'm like, well, I represent the West Side. And come to find out they were from Crescent, but they didn't want to admit it. It's kind of a horrific little town.
That's funny.
But they were known for a long time, the Kerr-McGee plant was located just south of Crescent. Most people who lived in Crescent worked at the Kerr-McGee plant. It was located on the Cimarron River. It was called the Cimarron facility. And they manufactured fission material. I think it was plutonium, not enriched uranium. I think it was plutonium. And so, you know, when you'd go into the facility, you had to hold your hands up and they would scan for nuclear decay on your hands. And if that happened, then there's a horrific scene in the movie Silkwood where they run them into the showers and they give them what has affectionately been called a Silkwood scrub down after that movie. So, you know, if you are a female who was working in the plant and you contracted or you had an exposure to high doses of radiation, it could affect pregnancy should they deny females the right to participate in those jobs. Why not?
Not every female wants to
Their
have a
choice.
baby. If they do want to be pregnant, usually it's a choice, and if they choose to do that, then they should be smart enough to be like, hey, maybe I shouldn't work this job anymore.
Okay.
I think
Their
humans-
choice.
Also accidents.
I think humans should be weary playing around with plutonium in general, but it's another debate.
It's not just, I mean, this is not just plutonium that can have these effects. I mean, working in other kinds of chemical plants could present problems for individuals who want to, become pregnant.
But I feel like if you're applying for a job in a chemical plant, you know that in some degree. So maybe don't go for that job if you're trying to like. if
But
that's
you think
your
it should be an
goal.
individual choice?
Yeah.
Right, we shouldn't violate your right to autonomy and making your own choices based on whether or not we think that that's a very paternalistic attitude. What these cases highlight are that there are different senses of rights in the workplace. We can talk about, for example, contractual rights in the workplace. What do you have contractual rights to? For example, if the employer has to, and under the Affordable Care Act, employers over 50 people have to offer health insurance to their employees. Now, they don't have to pay for it all, but they have to have some kind of health insurance plan, right, for their employees. That's a contractual right, but it also contains elements of moral rights to it. So we can talk about contractual rights, we can talk about legal rights that you have. For example, the Occupational Safety and Health Administration administers the Occupational Safety and Health Act. And those are legal rights that we have as employees to basically be free from, a harmful work environment, or to be made aware of the risks of that environment, because not all jobs obviously can be absolutely free. Generally speaking, by and large, on the whole, college professors are, not a high risk group. We don't work in an environment that's highly risky, although as more and more school shootings are occurring, maybe we do work in a higher risk environment than I had once thought. But so we can talk about legal rights, contractual rights, and of course, what we mostly focus on in this class are moral rights and the interplay between those three types of rights. So work is controlled by other people. We're vulnerable in our work. Even as a college professor, although I will tell you this is one of the few jobs that you can have where you have a great deal of autonomy. What I choose to talk about in this class is largely up to me. They rely on the fact that I have some expertise in this field to choose the curriculum and talk about the things that I talk about. But it is controlled by others. The department head has the right to set what classes I'll teach and when I'll teach them and things like that. So we're vulnerable in these positions. And we should think about these legal rights, things like the Fair Labor Standards Act, the Occupational and Safety Act, the Family Medical Leave Act, the Employee Retirement Income Security Act, things like that, right? The Americans with Disabilities Act. Then we can talk about contractual rights. What is it that we can contract for? Now, in the United States, unlike other countries, generally speaking, we don't have a lot of employment contracts. Again, I'm unique in that as a tenured professor, I have an actual employment contract that's difficult to overturn. And it can be difficult to release college professors. It's one of the reasons that I chose this profession. Most of you, and in many instances, most corporations only have employment at will. They don't offer a lot of contractual rights. And then, of course, moral rights is what we're really interested in this class. So one of the things that we talk about,
If you're under contract, employment at will is no longer at play.
Now, what happens in a lot of instances is companies will come up with something called an employee handbook. and employees will try to bootstrap that into a contract. Now, everywhere in the handbook, it's probably gonna say things like, this employee handbook is just general principles. It does not create an employment contract, and we still abide by employment at will. You can overcome that by showing a pattern of practice that they followed it in every other instance except yours, which becomes problematic for employers. Having practiced employment law, I can tell you that employee handbooks always become plaintiff's exhibit 1 in every piece of litigation that I've ever experienced. They use the handbook against you. So, but yes, we have a contract, and that contract is pretty difficult to undo. Which is one of the reasons that I chose this profession, because it's one where, you know, they give it to you, and it's hard to take away. When I used to do the employee training for hiring, we would go and we would talk to screening committees. And one of the things that I did like is there was a dean here on campus who she would speak before me about the position. And she said, I want you to remember this, that hiring here is very, very critical, because you can divorce your spouse, but a colleague may be forever. Once you hire somebody, you can't, and they get tenure, it can be very, very difficult to undo that. So right to work. There are several senses, and there is a moral sense to this idea of right to work. Right to work laws have become popular in the United States over the past 2 decades. What is right to work legislation? And one of the reasons that people, I think, vote for it is because they don't understand what right to work means from a standpoint of legislation and voting on right to work laws. Right to work laws mean that you cannot be forced to join a union, or if you don't want to join the union, to pay for the portion of union membership that goes towards collective bargaining. And we passed this in Oklahoma. We have very few unions in Oklahoma, and you can't be forced to join them. Now, what's the problem with this? Now, a lot of people voted for it, overwhelmingly passed, because Oklahomans have a tendency to not like things like unions. Why? I don't know. We have a tendency to think that unions they abuse their positions. If you are a unionized shop, it's hard to fire people. They can be rehired. I can tell you, the first time I was on city council, we had several police officers that we had a problem with, and they're unionized, and they managed to, through arbitration, get their jobs back, even though we consider them somewhat of a danger to the community. The first time I was on city council, they wanted to, for example, have a SWAT team. They wanted to form a SWAT team. In Guthrie, yep. And I said, well, why is it that you want to form a SWAT team? And they said, well, Stillwater used to loan us their SWAT team, but the last time they came down here, they busted down the door of the wrong person, and they scared the baby, and they got sued, and they got a judgment against them for $27 million. And I said, well, that's why I don't want to have a SWAT team. And they said, but you don't understand, Stillwater won't loan us their SWAT team. And I'm like, right, because they got sued for $27 million and lost. That's why I don't want to have a SWAT team. And they reverted back to, but you don't understand, we got to have a SWAT team because Stillwater won't loan us theirs. And I'm like, okay, whatever. It was the same reaction that I got when they wanted to buy the police pursuit package. And I'm like, why do you want to buy the pursuit package on these vehicles? It increased the cost by about $25,000. Well, so that we can go really fast. And I'm like, well, there's a state law that says that you can't go really fast. You're not supposed to do that. You're not supposed to engage in high-speed chases. So why do you want this pursuit package? So that we can go really fast. Again, there's a state law that says don't do this, but we need to go really fast. No, like, I mean, it was an interesting conversation. So you can be forced to, rehire these people in arbitration and things like that. The problem with right to work laws from the union's perspective is that it creates a free rider issue. What is a free rider issue? You all have probably experienced, and as I was listening to some conversations this morning as you're coming in, the free rider problem. You all have, in other classes, they require group work, right? And you hate group work, don't you? You absolutely hate it when you have to form groups, because there's always one person in the group who's the free rider. They don't pull their weight. And because you all want to make sure that you get a good grade, you basically end up doing their portion of the work and they get the grade for it, right? Now, the reason that we do this a lot in business is we say, well, you're going to encounter these problems in the workforce, right? You're going to encounter people that you work with that just don't pull their weight. The second meaning of right to work is the one that's more interesting to us from a moral philosophy standpoint is, do you have a right to a job? The faith of the Holy See suggests that yes, we should focus on social contract philosophy and this idea that people actually have a right to a job. If we say that, who then should provide the job? Should we rely on government to provide the job? Or should we force the private sector to shoulder the burden? Well, one of the things in a capitalist society that you say is, well, that's a violation of capitalism. I have the right to control my company and make a profit. One of the responses to that would be, well, that's true, you do. But one of the things that government gives you and that government can take away, because rights in terms of a legal sense are defined by the sovereign, and that which the sovereign grants, the sovereign can ungrant, is the corporate form. We give corporations an enormous advantage by allowing them to form the corporation. Why do people form corporations? The biggest reason why we have corporate forms is to allow for the pooling of capital. The corporate form is very good at allowing for the investment of large amounts of capital. Why is that? Because once you have a corporation, the corporation is a legal person. Mitt Romney now politicians get in trouble when they speak the truth, right? So Mitt Romney was at a rally when he was running for president, and like these reporters, one from a very liberal newspaper was heckling him and was talking about corporations and things like that. And Mitt Romney said, "Corporations are people, my friend." And everybody laughed. But he's correct. Corporations are legal people. What does that mean? It means that they have the right to sue and be sued in their own name. They have the right to own property in their own name. And the Supreme Court has held that they have First Amendment rights as well. Now, obviously, they're not actual people, but they are legal people. They are legal entities with these rights. So by giving them this, what does the corporate form allow? Well, I can invest, and I do through my 403B, in a lot of corporations. If you didn't have the corporate form, everybody who was an owner of the corporation would be subject to unlimited liability. Now, would anybody invest in anything if you were subject to unlimited liability? No. If you could go after me, for example, if I invested as part of my 403B, if it was invested in Ford, and you had unlimited liability, when Ford came up with a Ford Pinto, you could go after all of the shareholders of Ford. Well, we don't do that. You're limited in the amount of your investment. So the most you can lose is the amount of money that you've invested in the corporation. That gives corporations an enormous advantage, doesn't it? And to those who we give enormous advantage, maybe we should expect something in return. An even more nuanced perspective from a moral rights perspective is, okay, let's suppose that we say you don't have the right to a job. But once you get the job, should you have a right to continued employment, an expectation of continued employment if you do the job well? Well, generally speaking in the United States, because again, we favor employers over employees, the answer is no. But there are places where you do. For example, in Puerto Rico, they have very strong laws that require employers to continue to employ people, as long as they are not going broke. Once you get a job in Puerto Rico, which is part of the United States, you can't just be fired at will after you've been served out your probationary period. So we can think of the right to work in three senses: a moral right to work, a legal right, which is the right to not have to be forced to join a union, and then contractual issues with regard to the right to work. Once you have a job, should you be allowed to keep that job? Employment at will is the doctrine that most states in the United States, and employment law is largely predicated on state law, although there are federal laws that come into play that most states use. It's a laissez-faire economic doctrine. And the idea is that you have the right to leave your employment and your employer has the right to separate your employment at will. What are some restrictions on this? And I will tell you that that is the theory at the law, but jurors hate this doctrine. If you are relying on this as an employer, you had better take care, because every single person, and I tell, when I was chief general counsel for a publicly traded company, my boss almost never wanted to fire anybody, but we did terminate a couple of people, and one of them was somebody who was covered under one of the Age Discrimination and Employment Act, ADEA, and he didn't want to settle with this guy. And so I took my boss to Walmart, a place that he never went because he, didn't shop for himself at all. He had somebody that shopped for him, and he would never have entered a Walmart. And I'm like, pick out 12 people. That's your jury pool. Juries are not made up of employers, largely. They're made up of employees. And I can guarantee you, if you have not had a bad boss, at some point in your life, you will have a bad boss. And jurors, if they can find any way to get around this doctrine, and they think that you have done an employee wrong, they will find a way to get around it. Right? If there's any legitimate way of them getting around it. And there are restrictions, for example, civil rights legislation, Title 7 of the Civil Rights Act of 1965 plays a part, obviously union, and then public policy. You can't, for example, fire people who are whistleblowers, even if you're a private corporation. So if they can find ways of getting around this, jurors generally hate the employment at will idea. So what about due process in the workplace? What should we have? So we talked about substantive due process. Substantive due process are those things that we think are parts of fundamental fairness. What we should guarantee, people the right to make autonomous decisions, for example, for themselves, to not be subjected to dangerous working conditions. Those are substantive due process. How do we enforce those? Well, it's largely through procedural due process. So what is procedural due process and what is the heart of procedural due process? I generally try to focus on things that students would have some experience with. Let's suppose that I accuse you of cheating on an exam. What would you want in order to ensure fairness? Should I just be able to throw you out of the university, put it on your transcript that you were a cheater, and be done with it? That's what they do, by the way. They put it on, if you're expelled, they put it on your transcript. This is part of your permanent record. When you're in high school, you know, the principal, this is gonna be part of your permanent record. That's not really permanent record. Right? Like, that's not real people's records, but college, you know. They thought that I was going to be a criminal. I know my teachers thought that I was gonna be a criminal when I was in high school. I was a bad kid. And I'll never forget the first time I was 22, I got a job teaching here, and I saw one of my teachers and she's like, well, what are you doing now? And I'm like, oh, I teach at UCM. And she's like, they let you teach? And I'm like, yeah, big people school. Yeah. You teach little people school. What would you want?
Some type of like a trial like that.
Okay, yeah, you want something like that resembles a trial, right? You're gonna want to, first of all, what do we have when we have a trial? Well, you have some kind of notice, right? Of what it is. Why is it that I think that you've done this? So you want some kind of notice, and then you want a hearing. This is the heartland of due process, these two things, notice and hearing. Now, how much of these you get is dependent upon the context, right? So the more we can hurt you, the more trial-like it becomes. Generally speaking, in the workforce, private employers are not required to do this. Public employers are. So in public employment, if they want to terminate me, for example, they're going to have to say that I did something. You cannot terminate me for anything other than cause. What constitutes cause? Well, it's going to be things like, you know, committing a crime, things like that, not doing my job, not showing up and teaching my classes when I say I'm going to. And what am I going to get? Well, I'm going to have the right to a hearing as part of that. Now, again, how much of a hearing you get is dependent upon, you know, sort of the context in public employment. In private employment, you don't have to have any sort of due process. But what I will tell you is that from a utilitarian ethical standpoint, companies that don't engage in some level of due process, if employees don't feel like they are valued, they oftentimes have problems and they have turnover issues. And the problem with that is that, yes, you can replace anybody, but at what cost? At what cost? Amazon did this for a long time. They still have an enormous amount of turnover in their employment. So initially they had a forced ranking system. What does that mean? That you had to rank all of your employees, and the bottom half were automatically, the bottom 10% or something were automatically terminated, even if they met their quotas. It led to things like people not going to the bathroom. They were going to the bathroom in Coke bottles and leaving them all over the place. Because if you missed your quota, you might get fired, or you might get put in that lower half. Amazon stopped doing that. Because if you have this revolving door of people going in and out, it can cost your company money. You don't have to do it, but from a practical standpoint, it's good business. If people don't feel like they're valued, if they feel like they're treated like cogs and machines, they're going to behave like cogs and machines. You're going to get the bare minimum out of them, right? So how much hearing do you have? Well, notice you should be informed of what it is that you did, and you should have the right to have a hearing. Now, who's going to be in that hearing? For you, if I accuse you of this academic misconduct, this academic crime, what kind of hearing do you want? Should I be the one that makes the decision? No, right? Probably you want people that are not, my friends on the committee. You might want
A peer.
You might want peers on the committee, and we do that. We put students on these committees. I will tell you that in my experience, having sat on these, then the attorney that was assigned to these committees, grade appeals and things like that, students are always harder on students than faculty are. It's incredible to me. Students are always, I mean, there was one committee that I sat on where the professor was just clearly wrong. And the students and the faculty were going, he's clearly wrong. And the students were like, yep, hang him high. You know, I was like, what? What are you talking about? You know, and I'm crazy. But you might want, people that understand your point of view, like your peers on there. Participation rights in the workplace, workplace democracy. What should we have? Well, what are the arguments in favor of it? Well, again, these are utilitarian. This is utilitarian ethics at work. It creates conditions of self-respect. And employees who feel that they are respected and valued tend to be better workers than those that don't. It can increase or decrease alienation and burnout. If you just feel like you don't have any participation, you don't have any say in the direction of the company, you may not feel like, it's just like I'm just going through the motions. And it fosters greater social participation. It engages employees in the idea of living the brand. Now, of course, managers generally say, well, this is violative of property rights. It leads to problems because workers obviously don't have managerial expertise maybe. However, in the modern workforce, is that really true? Most employees now, in jobs, for example, that you all want, and the reason that you're here, are highly educated. And so you have some level of expertise when you go into those jobs. And of course, the biggest argument against it from the manager's perspective is efficiency, right? My argument against that would be that you can be enormously efficient and not necessarily effective. Efficiency and effectiveness are not the same things. Again, during the 1980s and early 1990s, it was fashionable for corporations to engage in massive reductions of force, particularly of older employees, in order to hire younger people. When you do that, you lose a lot of institutional knowledge about the company, right? Any questions about, I'm not going to talk much about employee health and safety because those are covered by OSHA. That's just a legal right. We will talk a little bit about privacy in the workplace. What do you have an expectation of privacy for? Is privacy dead? The average American now is photographed something like 110 times a day without even realizing it. Every time you go past an automated teller machine, every time you go into a business like Walmart, you're probably photographed. We have cameras out here on the lake to make sure that you're not jumping into, I don't know why anybody would want to do that. But, we've got cameras out there on Bronco Lake. We've got cameras on the parking lot. You're photographed constantly. Is privacy dead?
Yes.
In that sense, yes, but as someone who likes true crime, I kind of like that because, like, what happens if something happens to me? I want someone to be able to figure it out, and then there's like proof. So.
That is,
Because I worry about that every single day. I'm like, am I gonna get murdered today? And I just want someone to be able to like figure it out.
I would be more concerned about the murder. Like I want to live, right?
Yeah.
But you want somebody to figure it out if
Yes.
that happens.
Yes.
You have this fear often
Yes.
of being murdered.
Oh,
I watch too much true crime. I probably should stop.
Yeah, probably.
oh.
I think that's probably a good idea.
Yes.
Do you have much privacy in the workplace anymore? No. Should you? Well, again, employers will say, no, I provide you with this office. I should be able to come in and search it. The problem is that if people feel that you're doing that indiscriminately and for no good reason, that, employees will find ways of getting around that. During COVID, when everybody went to work from home, 70% of employers said that they were engaging in monitoring employees' work. What were they doing? Well, they were turning on cameras, in software that they had given you, you know, and on your computers or laptops that they were giving you, to make sure that you were, you know, actually there and working. They were monitoring keystrokes to see and monitoring web pages that you were surfing. Generally speaking, when you have that kind of attitude, I think you breed or you foster some contempt on the part of employees. So it's a balancing act to balance these legal, contractual, and moral rights that we think about. Next time, we'll talk about employee responsibility. So if you have rights, you also have responsibilities, and that will be the topic for next week. So good luck on the second exam. I have not graded the article reviews because I've given several people extensions. If you need an extension, let me know. And as soon as those are all in, I try to grade everything at one time so that everybody gets the same, whether I'm in a good mood or bad mood, you know, it doesn't affect things. Generally, when I start grading, I'm just not in a great mood, you know, but.
Is exam 2 the same format of like
Yep.
multiple choice and essay?
Yep.
The same expectations for essay?
Same expectations.
And that was,